Hi, everybody. My name is Ben. I am a law student, and today I'm going to be presenting my second video on contracts. This one is about the enforceability of contracts. So today we're going to be talking about consideration, reliance, and unjust enrichment. Before I get into it, standard disclaimer, this video is for educational purposes only and is not legal advice. If you need legal advice, get a lawyer. Also, the information in this video is accurate to the best of my knowledge, but viewers assume any risks resulting from the errors made by the creator of the video, me. Okay, so here's what we're going to be talking about today. I'm going to be presenting this flowchart to help you determine whether a contract is enforceable. This is something I made last year when I was taking Contracts 1. I found this to be a very helpful way to organize the information. I gave this flowchart to some of my classmates and they agreed. So I thought I would use this video to present it to a wider audience. So I'm going to walk you through it. I'm going to build the flowchart up piece by piece and explain each part as it appears. Hopefully this will be helpful for you. If it is, please like the video, subscribe to the channel, and consider making a donation. Okay, so let's get started. Now, big picture organization here. A contract needs one of three things to be enforceable. And we're going to break down each of these as we get to them, but I want you to have an idea of where we're going. The last video, we talked about offer and acceptance. We're going to get back to that. But offer and acceptance isn't enough. We also need consideration or reliance for the contract to be enforceable, or we could have an unjust enrichment situation, which we'll talk about, but I want you to keep these three things in mind as the big three categories: consideration, reliance, and unjust enrichment, to determine if the contract's enforceable. Now let's start at the beginning though. So I want to start where we ended last time. Last time, first video, we talked about offer and acceptance, sometimes called mutual assent. So we're going to start and we're going to assume we have that. We had a legitimate offer, a valid acceptance. Is that enough to have an enforceable contract? No. We're going to need more than that. One of the things we might have, in addition to mutual assent, is consideration. If we have mutual assent, the offer and the acceptance, and we have consideration, that's going to lead us to an enforceable contract. Of course, now you're wondering, what the heck is consideration? Well, my professor defined consideration as value-based inducement, and I think that's a very good definition. What that means is that both parties entered the contract in order to gain something of value to them from the other party. Both parties are motivated, both parties are induced to enter the contract to gain something of value. Okay, so a contract to give a gift isn't enforceable because there would be lack of consideration. Both parties need to be gaining something of value, and it doesn't have to be anything with a peppercorn of value. There's a saying that says that anything with a peppercorn of value will suffice here. We don't need the values exchanged in the contract to be equal in order for the contract to be enforceable. We don't have any concept of a just price or a fair price or what the market price is. None of those things are very relevant from the standpoint of contract law, as long as we have an actual bargain and not just the pretext of a bargain. As long as the court is convinced that both parties were entering the contract to gain something of value to them from the other party, even if the values aren't equal, even if the price isn't fair, we still have a contract. Now, I have a few more bullet points here, and these reflect other things that I encountered in my contracts course. So what are some things that could serve as consideration besides the obvious thing, money? There are some areas that you might not know what to do with unless you were familiar with the law. So one thing that can be consideration is forbearance of anything one has a legal right to do. So if you pay an adult to not drink or smoke, let's say, well, their forbearance of their legal right to drink and smoke would be consideration for the contract. even though those things are good to do anyway, even though that person benefits from not drinking or smoking, because they're giving up a legal right, giving that up, forbearance of something one has a legal right to do is valid consideration for a contract. Waiver of a valid or disputable legal claim can be consideration. Even waiver of a groundless legal claim when one believes in good faith that it's not groundless. So for instance, if a person gives up the right to sue their job over an injury at work, and they believe that they had a real lawsuit there, even though they didn't, because they would have had to have dealt with their claim through the workers' compensation system, as long as they believed in good faith that they had a legal claim, waiver of that claim could be consideration for a contract. Also, continued at-will employment can be consideration for a contract. Okay, so those are some examples of some borderline things that courts have held count as valid consideration for a contract, in addition to the obvious thing, money or some good or service that obviously has value. What wouldn't be consideration? Well, an exchange of a smaller quantity for a larger quantity of an identical thing at the same time and place, courts are going to look at that as a pretext for a bargain. So if two parties entered a contract in which one is going to give $1 in exchange for $100, that's going to look like a pretext of a bargain because they're trading the same thing, US dollars, just unequal in amount at the same time and place. It's not like it's a loan. Or, you know, if you probably couldn't trade a pound of flour for 100 pounds of flour in a contract if it's the same flour and the flour is being exchanged at the same time. There's no value-based inducement there. The party getting the lesser amount couldn't possibly be induced into that bargain by gaining something of value. So there's no value-based inducement. That would not be enforceable. That would lack consideration. Okay, one more thing to talk about here. We don't have consideration if we have an illusory promise. What's an illusory promise? This is going to be a promise with an explicit zero value option or a non-performance option. So if a party enters a contract and what they agree to is, I will buy as many as I want, well, the amount that they want could be zero. So if they want zero, they're agreeing to possibly not buy anything. That's going to be an illusory promise. But we need to be careful with the language here, because if they say, I will buy as many as I need is different from want. Now you might think, well, what if they don't need anything either? Well, the UCC, if we're buying as many as I need, we're probably transacting in movable goods. So we're probably governed by the UCC. And the UCC interprets this as any good faith quantity that's not unreasonably disproportionate to a stated estimate. So if you're a restaurant and you're telling a farm that you'll buy as many tomatoes as you need, well, this is going to be interpreted as not an illusory promise because you're expecting to need some amount that's greater than zero. Also, an exclusivity deal. If a producer gives a retailer the exclusive right to sell the thing they produce, well, this could be a zero value option, because what if the retailer just sits on their hands and doesn't sell anything? That could be a zero value option, but both common law and UCC are willing to read in extra terms, essential terms, into an exclusivity deal, basically to imply reasonable efforts or best efforts to sell the goods in the case of an exclusivity deal. So that would not be considered an illusory promise. It would count as consideration to make the contract enforceable. Okay, so I hope that makes sense as to what consideration is. So if we have offer and acceptance, we need also consideration as one of the pathways to make a contract enforceable. Now, what if after this, one of the parties wants to modify the contract? The parties have agreed, there's consideration. Someone's renting an apartment. I'm going to rent this apartment for $1,000 a month. It's an agreement, it has consideration. But what if I fall on hard times and I ask my landlord, I'd really like to reduce the rent to $900 a month. Is that okay? Now, I don't know what landlord's going to say yes. Maybe they're a very nice person. And they say, yes, okay, I'll reduce your rent to $900. And then I pay $900. And the next month they say, you know what? I've changed my mind. I'm putting it back up. Can I say, well, no, it's 900. You agreed. We modified the contract. No, that's not going to work for me because a modification needs new consideration. New consideration. So if they're reducing the price of my rent, I would need to be providing some kind of new consideration for that value I'm gaining. Now, if I was going to take on some kind of maintenance task, I'm going to rake the leaves and sweep the walk and clean the gutters in exchange for reducing my rent, that could be okay. That could be enforceable. But alone, just the reduction of rent, that's not going to be enough. So what are some things? Here's just a few more things that might count or not count as new consideration to make a modification of a contract enforceable. The affirmation of a legal duty subject to honest dispute, that could count as new consideration. Performance of a duty that's already contractually owed to a third party, that could count as new consideration. But what cannot count as new consideration is affirmation of a pre-existing duty. That's not going to be new consideration. Let's think about an example of that. So let's say I hire a contractor to build me a house, and I'm going to pay them $100,000 to build the house. And then they build half the house, and they say, you know what, to finish this, let's make it $200,000. That sounds like a nicer number to us. So they want me to give them the $200,000, and in exchange, they will finish the house. Well, is that new consideration? No, because in that situation, the contractor is simply affirming the duty to finish the house, which was already their duty under the initial contract. So that's not new consideration, that's just affirmation of the duty they already had under the first contract. Not going to work. So new consideration, like more money or something like that, we need new consideration in order to modify a contract, even if both parties agree to the modification. The modification can't be enforced even if both parties agree unless there is new consideration, or there's one other way, the modification could be fair and equitable under circumstances not anticipated by the parties, that's under common law, or it could be modified in good faith, that's under the UCC, and those mean basically the same thing. So what would that look like? Well, let's say a city contracts with a waste disposal company, and that company is going to pick up all the garbage in the city, and in exchange, they're going to get $5 million a year. And let's say in the course of this year, the population of the city doubles for some reason. Lots of people want to move to this city, this town, more realistically. So now the waste disposal company, they have a lot more work to do, and they might ask for more money. Now, for that more money, they're doing what they already agreed to do, picking up all the trash in the city or in the town. There's just more trash to be picked up. But that modification would be fair and equitable, or would be likely to be fair and equitable under the circumstances if neither party anticipated that the population of this town was going to double and the waste disposal company would have so much more work to do. They didn't anticipate that. Paying them more for that extra work is fair and equitable under the circumstances. Okay, so that's going to be a way to have a modification of a contract without new consideration. We either need new consideration, or we need the modification to be fair and equitable under the circumstances, or made in good faith. So that's going to make our modification enforceable. Okay. And the policy behind that is that we want to prevent shakedowns and holdups. What does that mean? Well, if you think to the example I used a minute ago, you have a contractor building a house. They've agreed they're going to build it for $100,000, and then they build half of it, and they say, you know what, we'd really like to have $200,000, or we walk away. Well, that's a shakedown. That's a holdup. They're asking for more money, significantly more than the initial agreement, to do the thing that they already agreed to do. Now, in that situation, the person who contracted to have the house built might be in a tough spot. It might be hard for them to find another contractor to finish the halfway built house. So they might be under a lot of pressure to pay this person what they're asking for. But the law tries to prevent that from happening by saying a modification needs new consideration. The person can't just simply ask for more money in the middle of the project, far more money like that. So that's the policy behind those requirements for modifications. Okay, now let's talk about reliance, which is also sometimes called promissory estoppel. So reliance is a substitute for consideration. So if we have an offer and acceptance, consideration is one path to making the contract enforceable. The other path is reliance. What does that mean? It makes the contract enforceable, but what is it? Reliance means that there's a promise, and the promise is reasonably expected to produce reliant action, and does actually produce such action, and justice requires the enforcement of the promise. And what exactly do we mean by justice? Well, justice would be assessed based on the reasonableness of the reliance, the extent of the reliance, the formality of the promise, general fairness. Now, this is all very abstract. So let's talk about the most typical case of reliance. The most typical reliance scenario is when we have a general contractor, and that general contractor solicits bids from subcontractors to complete some kind of project. So you have a general contractor who's going to submit their bid to build a building, and that general contractor has in turn solicited bids from plumbers, electricians, carpenters, all of the people, all of the different subcontractors who would do the specific tasks necessary to construct the building. Well, if the electrician says, I can do all of the electrical wiring work for $50,000, that general contractor is going to rely on that $50,000 bid when they make their bid to the person who wants the building constructed. So that bid by the subcontractor, it's a promise. It is reasonably expected to produce reliant action. In other words, the subcontractor can reasonably expect that the general contractor will rely on the subcontractor's bid when the general contractor comes up with their bid. And in our hypothetical, we're saying it does produce such action. And then justice requires the enforcement of the promise. Why is that? Well, if we think about it, if the general contractor submits their bid and they win, they get the project, and then they go to start constructing it. And then the subcontractors can say, well, actually, we said $50,000, but we really meant $200,000. Well, then the general contractor is kind of in a bad situation in that case, because they're still on the hook for the bid that they put in. So they'd have to build at a huge loss if the subcontractors could change their bids after that point. So the law tries to protect the general contractor in those cases. Justice requires the enforcement of the promise because in that situation, it's reasonable to rely on the subcontractor's bid. It's relied on to a great extent in formulating the general contractor's bid. It's probably a fairly formal promise if it's submitted on a piece of paper, let's say, as part of a formal bidding procedure. It's generally fair to require the enforcement of the promise in this case. So that's what we mean by reliance. Basically, somebody makes a promise, that another party relies on to their detriment, and so justice requires the enforcement of the initial promise. This is a substitute for consideration. So mutual assent plus reliance, we have an enforceable promise. Also, a gratuitous promise plus reliance will get us an enforceable promise. So let's say I'm a rich guy and I meet a person and this person is working a dead-end job and they're not very happy, and I say, hey, you know, I don't like to see you struggling this way. I'm going to pay you $5,000 a month for the next 10 years just so you can explore your life and see where it takes you. Well, that would be a very nice thing to do. And that promise would reasonably produce reliant action. So that person would be likely to quit their dead-end job because they have another way to support themselves now, or so they think. But let's say they quit their job, I give them the $5,000 the first month, and then the second month I say, I've changed my mind. I want to hold on to my money. Well, now that person is in a bad way because they've quit their job. They might not be able to get it back. So because that person reasonably relied on my promise, and let's make the facts even more clear. Let's say I put it in writing, you know, it's a very formal promise. Well, there's a good chance the law is going to hold me to that promise because the person has relied on it to their detriment, and that's going to make my gratuitous promise enforceable. Reliance as a substitute for consideration. All right, finally, unjust enrichment, the third path to an enforceable promise. This is also known as moral obligation. So what is this? This is a very strange set of circumstances, but it's a thing. So unjust enrichment is the conferral of a material benefit that is non-gratuitous, non-officious, and unjust to retain without compensating the benefactor. Okay, and non-gratuitous means it's not a gift. This would be assessed based on the relationship between the parties, the extent and sort of the benefit. Non-officious means it's wanted and not meddling. So again, this is very abstract. What are we talking about here? Well, let's come up with an example. Let's say I'm walking in the park, national park, and I see someone drowning, and I jump into the river and I save them from drowning, and I injure myself in the process, but I pull them to shore. I don't know this person, they're just a stranger, and they're yelling for help. Okay, well, I've saved them from drowning. I've conferred a material benefit. It's non-gratuitous. Now, this is going to depend on the facts, but here we've said, I don't know this person, they're not a friend, they're not a family member. Maybe I'm just being a good person, maybe not, who knows. It's non-officious, though. It's wanted. It's not meddling. This person was yelling for help, and they've received this benefit. Now, this isn't enough for unjust enrichment. We also need a post-benefit promise in recognition of the benefit. So in this scenario, I pull this person to shore, and they say, thank you so much for saving my life. I see that you've injured yourself doing it. I'm so grateful. I'm going to give you $10,000. And I'm like, great, I love $10,000. So now we have an enforceable promise. If they try to welch on the $10,000, I could, if I was the type of person, sue them and try to get that money because they've gotten this benefit. They've made me a promise in recognition of the benefit, and so the law says it would be unjust for them to retain that. So that is an unjust enrichment scenario. Now, there's one more kind of unjust enrichment scenario that's similar but not quite the same. We could also have an unjust enrichment scenario in which there's a previous contractual duty that has been breached but has become unenforceable due to the statute of limitations or bankruptcy. So somebody, let's say, owed me money under a previous contract. They never paid me. Maybe the reason is they went bankrupt and they couldn't pay me. Maybe the reason is that the statute of limitations to enforce the contract has expired, but this person owed me money under a previous contract. They never paid, but I'm not legally able to enforce that contract anymore. But this person has now made a new promise to fulfill that prior contractual duty. They say, you know what, I feel so bad I never paid you that money from that other contract. I promise I will pay you, even though legally you can't make me anymore. Well, guess what? By making that promise, now legally I can make them if I were so inclined. This also creates an unjust enrichment scenario, which leads to an enforceable contract. So there you have it. These are the three ways that a contract can be enforceable: the consideration path, the reliance path, and the unjust enrichment path. These all lead to enforceable contracts. So thank you very much for watching this video. I hope you enjoyed it. I hope you learned something. If you did, subscribe to the channel, like the video. Those things are absolutely free to do. Now, if the video was very helpful to you, I hope you would consider making a donation on Patreon, Venmo, Cashapp. I will leave the information about that in the description. Thanks again for watching. And I want to thank my supporter on Patreon, Kate Lyon. Thanks for your support. I appreciate you. And I will see everybody in my next video.